Today I'm going to be talking to you about the Renters' Rights Act and more specifically the changes that that particular piece of legislation is introducing to the assured tenancy regime as of 1st of May 2026. So just to recap about what this is all about, this is a training session looking at assured tenancies, the regime for which is set out in the Housing Act of 1988. And that regime is going to be significantly changed by reforms being introduced by the Renters Reform Act that take effect from 1st of May 2026. There are some things that I won't be covering in this session for the sake of convenience and speed. I won't be covering things such as low-cost tenancies, social tenancies, agricultural oral, or indeed legacy tenancies. I'm focusing in on the key changes being made to the private rented sector. Also, the changes are only applicable to England, so what I'm about to talk about does not apply in Wales or any other jurisdiction. I'm also not touching on shared ownership leases, lettings by charities, or any assured tenancy that transitions under the new rules that was previously not an assured short-hold tenancy. I'm going to be focusing on how assured short-hold tenancies are affected by the changes. So the first question to ask yourself, if you're wondering whether these reforms affect you or the document that you're looking at, is to ask yourself, is the tenancy I'm looking at in scope? And the criteria for an assured tenancy are set out in Section 1 of the Housing Act 1988. And it's important to determine whether you're dealing with an assured tenancy, because if you're not, the changes are not going to be relevant to you. So looking at the criteria from Section 1, we know that you need to have a tenancy. So, for example, if the arrangement you're reviewing or looking to put in place is genuinely a license arrangement, it can't be an assured tenancy. Now, be careful here because it is the substance of an arrangement that matters, not the label that you give to it. So there's no sneaky way out of these reforms by labelling your arrangement a license, if in fact it is a tenancy. The next requirement is that it is of a dwelling in England and it's let as a separate dwelling. As I mentioned just now, these reforms do not apply outside of England. Is the tenant an individual, or in the case of joint tenants, are they all individuals? If they're not, it can't be an assured tenancy and it won't be in scope. If you've got joint tenants and one is an individual and one is a company, that's not enough. All the tenants need to be individuals. The next requirement is, does the tenant occupy as their principal home? Here, all that matters is that one tenant occupies as their principal home. Now, principal home is to be judged objectively on the facts, but you can see how if you've got one tenant and actually they're just using the premises as a holiday venue, then perhaps it's not going to be their principal home, and so therefore they wouldn't tick that criteria. Next, the question is it an excluded tenancy? And Part 1 of Schedule 1 of the Housing Act 1988 contains quite an extensive list of tenancies that cannot be assured tenancies. I haven't put all of those exclusions on this slide, but I have put the key ones on. So, for example, one of the things you would be looking at is the level of rent payable. If it's greater than 100k, then it's going to be out of scope. And if it's a rent below £1,000 in London or £250 a year elsewhere, that too will be out of scope. From 27th of December 2025, a new exclusion came in for any tenancies with a term certain of more than 21 years. There's also a quirky exclusion for those which have a term certain of less than 21 years but more than 7 years, if that tenancy was granted at a particular time or pursuant to a particular agreement granted before a given date. There's an exclusion for student lettings, but I'm going to talk about that in more detail later in this presentation, so I won't go into it here. All you need to know is that there is a student lettings exemption. Business tenancies are also out of scope, so where security of tenure could apply, that type of letting is not going to be an assured tenancy. And as I've mentioned, there are other exclusions set out in Part 1 of Schedule 1 of the Housing Act, which you may find useful in certain situations. But ultimately, you work through the flowchart and you work out whether you are dealing with an assured tenancy. If you're not, then it's not an issue. If you are, then what follows in this presentation is going to be really important. Once you've determined that you're dealing with an assured tenancy, you then need to spend a bit of time working out what type of assured tenancy am I dealing with. And for these purposes, it's really all about the question of when the tenancy was granted. If the assured tenancy is being granted on or after 1st of May 2026, it will be an assured periodic tenancy, an APT, and all the rules will apply in their full fat form. If, however, the tenancy was granted before 1st of May 2026, there's a subsidiary question you should ask yourself, which is, has a valid Section 8 or Section 21 notice for possession been served before 1st of May 2026? That's important because if there is a valid notice in play, then there are transitional provisions that provide for that process, that termination process, to proceed under the old rules and for the tenancy not to become subject to the new rules whilst that's ongoing. There is a limitation insofar as possession proceedings must be sought within 3 months of the 1st of May, but that's an important exception to watch for. If, however, no valid Section 8 or Section 21 notice has been given, then what you're dealing with is an assured tenancy, which is going to automatically convert to an assured periodic tenancy on the 1st of May 2026, and the rules will apply subject to the transitional provisions, and that's quite important. So once you've gone through that thought process, you'll end up in one of 3 buckets. The first bucket is that you're not dealing with an assured tenancy. You don't need to worry about what I'm going to say. The second is that you're dealing with an APT and the rules apply without modification. The third bucket is that you're dealing with a transitional APT. That is an assured tenancy that's converted on 1st of May 2026 and is therefore subject to the rules as modified by the transitional provisions. This becomes important when we look at what the key changes are that are coming into effect on 1st of May 2026. And the slides that follow, I've adopted the same approach to all relevant terms. On the left of the slide is the position for a normal APT, that's one granted on or after 1st of May 2026. And on the right of the slide is the position under the transitional provisions insofar as it differs. So the first slide deals with term, and the first important change to note is that from 1st of May 2026, all assured tenancies will become periodic with a maximum period of 1 month. Fixed terms will no longer be permitted. So if you've got an existing AST, that will convert to a periodic tenancy on the 1st of May. That fixed term will be overridden. There are provisions that deal with how you calculate the periods if you've got a transitional APT. And as I've already mentioned, your assured tenancy won't convert on the 1st of May if there is a valid Section 21 or Section 8 notice in play before that date. Moving on to rent and rent review. From 1st of May 2026, rental bidding will be prohibited. Landlords and their agents will be required when they're offering or advertising a letting to state the rent. That must be a specified figure. Thereafter, they are not allowed to invite, encourage, or accept rent in excess of the stated amount. If they do, they will be in breach. And we'll come on to the duties in relation to that in a moment. In addition, from the 1st of May 2026, there will be a ban on rent payments in advance being made before the tenancy is entered into. And again, landlords and letting agents must not invite, encourage, or accept any rent payments in advance of a tenancy being entered into. Equally, there is a ban on rent payments in advance after the tenancy is entered into. There is an exception which would permit the payment of 1 month up to 1 month's rent in advance between the signing of the tenancy document and the tenant taking possession. Also, this does not prevent rent being paid, for example, on the first of the month, if that falls within the relevant rent period. So you pay rent monthly, and the agreement provides that the rent is to be paid on the first of the month. That is permitted. What you can't require is for the rent to be paid in advance of the period to which it relates, unless it falls within the narrow exception for the 1 month's rent payable before the tenant takes possession. However, if you were dealing with a transitional APT, that ban on rent payments in advance after the tenancy is entered into does not apply. Rent reviews. Significant changes are coming in. Whereas previously you could provide for a contractual rent review, going forward from the 1st of May 2026, the only way in which the rent can increase is via the Section 13 procedure in the Housing Act 1988, which I will go into in more detail. Contractual rent reviews will be of no effect. And the Section 13 procedure, as amended by the Renters' Rights Act, will not permit rent reviews in the first 52 weeks of the term, nor more frequently than once a year. Under the transitional provisions, any rent reviews under a converting tenancy won't be affected. But there is a transitional provision making sure that if there has been a contractual rent review under an assured tenancy that's converting, that the landlord can't use the Section 13 procedure to procure another rent increase within 52 weeks of the previous increase. So let's just step aside, and have a look at challenges. The tenant can challenge the rent payable in the first 6 months of the term via Section 14 of the Housing Act. And if it does so, it will go to the tribunal that will be able to award the open market rent, but only if that is lower than the rent payable. The tribunal does not have the power to award an increase in the rent payable. If it does make a determination, the rent that it determines will take effect from the date that the tribunal directs, but cannot be earlier than the date of the tenant's application. There are transitional provisions ensuring a smooth transition, because previously under the assured tenancy regime, excessive rents could be challenged under Section 22. Going forward, the transitional provisions make way so that rents would simply be challengeable under Section 14, but again, it's only within the first 6 months of the term. When it comes to rent reviews, the tenant can challenge a rent review, again via Section 14, and if it does so, the tribunal can award the open market rent, but again, it cannot award more than the open market rent or more than the rent stipulated in the landlord's notice. The determined rent will take effect from the beginning of the next rent period following the date of determination, but there is discretion for the tribunal in cases where it might cause undue hardship for the tenant to delay the increase in rent taking effect by 2 months. And there are transitional provisions preserving the process for challenging rent reviews under the old regime. So just having a look at the Section 13 process being the only way that landlords from the 1st of May 2026 can increase the rent for an assured periodic tenancy. The trigger will be the landlord serving a Section 13 notice in the prescribed form, and the landlord is going to have to give at least 2 months' notice of the proposed increase. And the increase can only take effect at the beginning of a relevant period, and you cannot have an increase within 52 weeks of the previous increase if there has been one. Once that notice is served, if the tenant does nothing, the increase will take effect on the date stipulated in the notice. Equally, the landlord and tenant are free to agree a lower rent if they choose to, and then that will be the new rent. But the tenant has the option of challenging the proposed rent increase via Section 14, as we saw on the previous slide. If it does so, The tribunal gets to determine what is the open market rent for the premises, and if that is lower than the proposed increase in rent, it can provide that will be the new rent. The new rent, if determined, will be payable from the date specified in the landlord's notice, if that's later than the date of the tribunal's determination. If it's not, then it will be the date that is the first day of a new period falling after the determination. But there is that rule, as I've already outlined, that the tribunal can delay the increase by up to 2 months in cases of undue hardship. So if you're landlord's side, there are a few issues. Firstly, it doesn't appear that there's any penalty for a tenant making a vexatious referral to the tribunal pursuant to Section 14. Secondly, we have the issue that the tribunal, if it does receive a referral, cannot award higher than the open market rent. So it cannot support an increase in rent if the open market rent is lower. Or indeed, if the open market rent is higher than that set out in the Landlord Section 13 notice, then the tribunal can't award that. The cap on the rent increase will be what's set out in the landlord's notice, even if the open market rent is higher. The determined rent is not going to be backdated to the date of landlord's notice. So if there is going to be a challenge, then this makes it far less likely that a landlord will be able to arrange a rent review yearly because of the delay that the process will introduce, and that will probably throw the timetable out. Once the rent is determined and comes into effect, 52 weeks have to pass before another increase can come into play. But where the Section 14 notice or challenge is used, that's probably going to mean that the landlord is not going to achieve yearly uplifts. There's probably going to be a bit of a lag in the timetable. So those are just some points to watch out for on landlord's side. Tenancy deposits, we already know that under the existing assured tenancy regime, ASTs and tenancy deposits, there are strict rules. They are going to continue, but with some modification. So for an APT, it's the same. The tenancy deposit is going to have to be held and dealt with in accordance with an authorised tenancy deposit scheme. And the landlord's going to be required within 30 days of receipt of the deposit to comply with the initial requirements of the scheme and to provide certain prescribed information to the tenant. There are all sorts of consequences that will flow if the landlord is not compliant. These include affecting the ability of the landlord to get an order for possession. Because going forward from the 1st of May 2026, the court will only order an order for possession where there has been compliance, unless we're talking about grounds 7A or 14, which relate to antisocial behaviour and criminal conduct. Non-compliance can also result in penalties for the landlord of up to 3 times the deposit amount. So it's really important that landlords comply with the tenancy deposit rules, which are largely the same as what we've got currently, with a few modifications. But those of you who are familiar with assured tenancy will know that the tenancy deposit rules currently only apply to assured short-hold tenancies. And so to make the transition smooth, where you've got a transitional APT, the tenancy deposit rules will only apply to transitional APTs that were assured short-hold tenancies before they converted. Other financial terms, there is provision that an individual guarantor will be automatically released from its guarantee in the event of a tenant's death in relation to payments due after the tenant's death. And there are provisions dealing with situations of multiple tenants, etc. But there will be that automatic release. But if you're dealing with a transitional APT, that automatic release will not apply if the guarantor became party to the guarantee agreement before 1st of May 2026. There will also be, in all cases, an automatic right for the tenant to be refunded any rent paid in advance that relates to a period after determination of the tenancy. Other terms, there will be a ban on rental discrimination on the grounds that the tenant has children or is in receipt of benefits. The provisions are quite strong, and there will be equivalent provisions coming into force in Wales and Scotland. But in England, the provisions are quite strong because they will overwrite provisions in superior leases, mortgages, and some insurance contracts that would prohibit the landlord from having someone occupy with children who is on benefits. So they're quite strong provisions protecting those with children and those in receipt of benefits to ensure that they are not discriminated against. Going forward, there will also be an implied term in every APT, whether it's transitional or not, allowing the tenant to request to keep a pet at the premises subject to landlord's consent, which cannot be unreasonably withheld. And the landlord will be obliged to give a decision in 28 days, and that decision must be in writing. There is no requirement and no ability for the landlord to insist that additional insurance is taken out by the tenant to cover any damage by the pet. There is one circumstance in which the landlord is expressly permitted to refuse consent, and that's where to give consent would put the landlord in breach of an agreement with the superior landlord, or it requires the superior landlord's consent, and despite taking reasonable steps, that consent has not been given. It's a very limited exception there. In terms of termination, this is really a headline area and one that's received a lot of attention in the press and media. Going forward, tenants will be able to terminate an assured periodic tenancy, whether it's transitional or not, by giving 2 months' notice, which expires at the end of a rent period. It doesn't matter if prior to the 1st of May 2026 there was a fixed term, the tenant just has to give 2 months' notice, and that cannot be restricted. It is possible for the landlord and the tenant to agree amongst themselves that the tenant can give less notice, but the default position is that the tenant need only give 2 months' notice to bring the tenancy to an end. Under the transitional provisions, any notices to quit given before 1st of May 2026 are unaffected. Termination by the landlord going forward can only be via the Section 8 process, and that requires the landlord to establish one of the statutory grounds for possession. Section 21 no-fault evictions are abolished for both APTs and transitional APTs. They will no longer be available. And that means that the landlord is going to have to establish one of the statutory grounds before it can recover possession. And it's important to note here that the landlord may have to give an advance notice of its intention or wish to rely on a possession ground before it enters into the tenancy, if it later wants to rely on it. So, for example, possession ground 4A, which is specific to student accommodation, requires advance notice before the tenancy is entered into, and that's an absolute requirement. In the case of the other grounds shown on this slide, for example, ground 1B, advance notice is required, but the legislation states that possession can still be sought on those grounds, but the landlord will be subject to a financial penalty if it hasn't given the advance notice. If we look at the position for transitional APTs, I've already mentioned that if there is a valid Section 21 or Section 8 notice in play for the 1st of May 2026, then that will be able to continue under the transitional provisions, although there is a deadline of 3 months after 1st of May 2026, within which possession proceedings must be sought. Ground 4A, the student accommodation ground, is also modified in relation to transitional assured periodic tenancies, and I will come on to that in more detail shortly. And also for transitional assured periodic tenancies, the duty to give the advance notice, for example, for grounds 1B, etc., is disapplied. And that makes sense because these tenancies are already in play. It would be impossible now to give advance notice before entering into them that the landlord wished to rely on those grounds. So there is a helpful disapplication there. On this slide, I've set out the mandatory grounds for possession, and I'm not going to go through it in detail. It's here just for reference, just to give you an idea of the breadth of the mandatory grounds for possession. And of course, if a mandatory ground is established, the court will order possession. There is a second category of grounds for possession, and those are the discretionary grounds, which are shown on this slide, where even if they are established, the court retains the discretion not to grant an order for possession. So I've mentioned student lettings a number of times now, so let's take a closer look at how the changes apply. And I think it's really helpful just to step back in the first instance and to understand that all of the changes that I've outlined just now will apply to student lettings that fall within the assured tenancy regime. There are just two particular twists to be aware of. Firstly, there is a new and expanded exception for certain student lettings that will come into force, or rather will become of assistance from the 1st of May 2026, and that will look to take more student lettings outside the scope of the assured tenancy regime and therefore outside of the scope of all of these changes. The other point, which is unique to student accommodation, is that there is a specific possession ground 4A, and I'm going to have a look at that in detail in this section. So looking at the student accommodation exclusion, so the types of student letting that cannot be an assured tenancy. Here we have to distinguish the position pre-1st of May 2026 and that for tenancies granted on or after 1st of May 2026. If the tenancy was granted before 1st of May 2026, the old exemption will apply, and that was quite narrow because it only excluded lettings by specified educational institutions or other specified institutions. So really it didn't offer any exception where student accommodation was being offered by a private provider rather than the educational establishment itself. So it's quite narrow. For student lettings on and from 1st of May 2026, an expanded exclusion applies. It's actually contained within Section 32 of the Renters' Rights Act, which came into force on the 27th of December 2025. But don't be fooled into thinking that the exception actually applied from that date, because the way in which it works and the way in which the regulations that supplement that exclusion work means that it can only apply and only avail tenancies granted on or after 1st of May 2026. The guidance is very clear from the government that this is not intended to apply retrospectively. The expanded exemption will cover lettings not only by specified educational institutions, which is the current or previous position, but also lettings where the landlord or its manager are a member of a specified housing management code of practice. And the relevant code of practice, as at the date of this recording, is the ANAC Unipol Code of Standards for Larger Developments. And if your landlord or its manager is a member of that code, then the letting will be excluded. So when you're approaching student lettings, it's the same thought process. The first question you're going to be asking yourself is it an assured tenancy? And you go through the flowchart. The one difference is that when you come to the question, is it an excluded tenancy? You just have to be mindful that the expanded exclusion will only apply to tenancies from 1st of May 2026. And again, the next question you're going to ask yourself is what type of assured tenancy is it? Because you want to know whether it's going to be subject to the transitional rules or not. And then once you've done that, it's the same terms as I've previously outlined. Save for the possession grounds, because ground 4A is the one that's specific to student accommodation. And on this slide, I've set out the conditions that apply if a landlord wants to avail itself of this possession ground. Note that we have a third category of assured tenancy coming in. Not only do we have straightforward APT and the transitional APT, but we also have a category where the student letting is a qualifying student letting. And the easiest way to explain that is it will be a qualifying student letting if it would have fallen within the expanded exemption had it being granted on or after 1st of May 2026. So you're looking at situations where the landlord, it's a private landlord, but is a member of the relevant code of practice, either the landlord or its manager. So the conditions for ground 4A. Firstly, it has to be a letting of a dwelling that is an HMO or in an HMO. That condition won't apply if it's qualifying student letting. Secondly, the tenant must meet the student test when the tenancy is entered into. The student test is effectively that the tenant is in is on a full-time educational course, or the landlord has reasonable grounds to believe that it's going to be. That test is slightly modified for transitional APTs and qualifying student lettings. So the question is whether the tenant met the test at the time the tenancy was entered into, or when the landlord gives its written statement. And the written statement in the case of APTs is required to be given before the tenancy is entered into. So before a student letting is entered into on or after 1st of May 2026, if it's in the assured tenancy regime and the landlord would like to have recourse to ground 4A, it's going to have to serve advanced notice of that wish. If it's a transitional APT or qualifying student letting, that advance notice requirement is modified, and instead the advance notice must be given by the 31st of May 2026, because obviously you can't give that notice in the case of transitional APTs or qualifying student lettings because they're already in existence. So the rules are modified, but the landlord must give that notice by 31st of May 2026. The next condition is that the period between the day on which the tenancy is entered into and the tenant takes possession is less than 6 months. That condition is disapplied for transitional APTs and qualifying student lettings. Next, the possession date must be between 1st of June and 30th of September in any year. That's because we're talking about student lettings and we need to be mindful of the academic year. That condition will not apply in the case of qualifying student lettings. In all cases, the landlord who is seeking possession must intend on the next occasion when the premises are let to a tenant who meets the student test when the new tenancy is entered into. Finally, the amount of notice that must be given pursuant to ground 4A is ordinarily 4 months. However, for transitional APTs and qualifying student lettings, if the notice is given between 1st of May 2026 and 30th of July 2026, 2 months notice is required rather than 4. The purpose here of having the qualifying student lettings category is because the government recognised that existing student lettings within the assured tenancy regime were going to convert, and that there would be difficulties in ensuring that the landlord could obtain vacant possession to ensure that lettings could continue in accordance with the academic year. So that's why you can see a number of concessions and the disapplication of various conditions, and it's to help landlords out. And those landlords who are members, or landlords who have managers who are members of the relevant code of practice, will benefit from greater concessions, because by being a member of that code, it's felt that the students will have greater protection, or will have a degree of protection by virtue of that membership. So let's just talk about some duties that are being brought into force on the 1st of May 2026 by the Renters' Rights Act. I've summarised them on this slide. We've already talked about there being a ban on rental discrimination on the basis of children or benefits. The duty to comply will apply to the landlord and anyone acting directly or indirectly on their behalf, with no specific exclusion for legal representatives. Breach can attract a fine of up to £7,000, although you can have multiple fines for multiple breaches. The next is the ban on rental bidding, something I've already mentioned, and again it applies to the landlord and anyone acting directly or indirectly on their behalf, with no exclusion for legal representatives. Fines again of up to £7,000 for a breach, but again possibility of multiple fines for multiple breaches. Next, we have the obligation to give the written statement of prescribed terms and information before the tenancy is entered into. And this falls on the landlord, and where the landlord has entered into a contract with a person whereby that person is to ensure compliance, it will also fall on them. It doesn't exclude legal representatives. Fines here in cases of persistent and multiple breaches can go up to £40,000, and there can be criminal liability where there's persistent bad behaviour. And then we've got a whole category of additional duties which are set out in the new section 16E to section 16G of the Housing Act 1988. So, for example, there's a duty not to let for or to purport to let for a fixed term, to purport to terminate by notice to quit, or to purport to terminate orally. You can't rely on a possession ground without reasonable belief that you can establish it. And as I mentioned, if you fail to give advance notice of the possession grounds 1B, 2ZA to 2ZD, 5 to 5H, 6A or 18, if you fail to give advance notice you want to rely on those grounds before the tenancy was entered into, and you later seek to rely on one of those grounds, you open yourself up to penalties. And there are additional duties in relation to situations where the landlord is relying on grounds 1, which is the occupation by the landlord or family, and 1A, which is the sale of a dwelling house. So if the landlord is looking to rely on those grounds, there are some additional duties. And these duties fall on the landlords and those acting or purporting to act on their behalf, although there is a specific exclusion for legal representatives. Again, here, fines can get up to £40,000, and there is the possibility of committing a criminal offence. There are a number of standalone criminal offences for breaching various obligations. Another key feature of the new regime is the need to serve certain advanced notices and information in advance. And so I thought it'd be helpful just to summarise that. So I've split this slide into APTs and transitional APTs. And the deadline for an APT to serve the advance notices is going to be before the tenancy is entered into. So in all cases, for an APT granted on or after 1st of May 2026, the landlord is going to have to give a written statement containing prescribed terms and information to the tenant. That must be done before the tenancy is entered into. Next, the landlord is going to have to give advance notice if it wishes to rely on ground 4A, which is the student accommodation ground, and that's an absolute requirement, and grounds 1B, 2ZA to 2ZD, 4, 5 to 5H, 6A and 18. If you were dealing with a social landlord, note that also you might have to give advance notice if you wanted to rely on possession ground 6, which is redevelopment. Where the landlord is a tenant under a shared ownership lease, it will have to give an advance notice of its status as well before the tenancy is entered into. If you're dealing with a transitional APT, clearly you can't give notices now before the tenancy is entered into because that horse has bolted. So under the transitional provisions, there are different requirements. So for all transitional APTs, each tenant must be given the Renters' Rights Act Information Sheet 2026. So that needs to be provided to the tenants by 31st of May 2026. If it's a student letting, the landlord may want to preserve its right to rely on ground 4A, and so it will have to give a notice to that effect by 31st of May 2026. And again, just to mention, although I'm not talking about them in any detail, if you're dealing with a social landlord and it may want to rely on ground 6 redevelopment, it may have to give an advance notice of that. Sorry, we may need to give a notice of that wish by 31st of May 2026. If the landlord is a tenant under a shared ownership lease, its notice of status must be given by 31st of May 2026. And finally, again, I'm not going into this in detail or any detail in this talk. Ground 5H, which is for stepping stone accommodation, also requires eligibility criteria to be given to the relevant tenants by 30th of April 2026. So it's really important to be aware of these requirements and to get the relevant information and notices to the tenants by the relevant deadline. Worth just saying beware, because residential lettings are a highly regulated area, and there are a plethora of legal obligations on landlords outside of the Renters' Rights Act reform, which I've not gone into in this talk. So, for example, and this is not an exhaustive list, there are obligations to provide EPCs, gas safety certificates, electrical safety reports. There are obligations on landlords to check the tenant's right to rent and HMO licensing requirements. So there are a number of other obligations that landlords must comply with, which I haven't touched on in this talk because I focus solely on the changes being brought in by the Renters' Rights Act. Of course, if you're in doubt, take specialist advice, reach out to your usual dentist contact who should be able to assist. The Renters' Rights Act is not just limited to the reforms to the assured tenancy regime that I've outlined. There are further reforms coming down the line, which is shown on this slide. So from late 2026, so later this year, we're going to see the introduction of the PRS database and ombudsman. In 2027, we're going to see the application of the assured tenancy reforms to the social rented sector. What I've been outlining today that's coming into force on the 1st of May 2026 is in relation to the private rented sector and assured tenancies granted by that sector. In 2028, there's going to be a mandatory requirement for landlords to be members of the PRS Ombudsman. And in 2035 to 37, we can expect to see the introduction of a decent homes standard. I thought it would be useful if I put in just a brief quiz if you wanted to test your knowledge on what I've gone through during this presentation. So if you want to test yourself, you might want to press pause on the recording now and go through these questions. Taking the first question, what is the structure of PRS assured tenancies from 1st of May? As I've discussed, they can only be periodic APTs. So periodic in the sense that they can have a maximum period of 1 month. Fixed terms are being abolished. Moving on to question 2. What is the key change regarding Section 21 no-fault evictions? Hopefully you all have appreciated from this presentation that Section 21 is being abolished and will not be available for any assured tenancies on or after 1st of May 2026. Question 3 asks whether under the new regime, how can landlords regain possession? And again, hopefully you have appreciated that the only way a landlord can regain possession under the new regime coming into force on 1st of May 2026 is via Section 8 and by establishing one of the statutory grounds for possession. There is no possibility of a no-fault eviction. Landlords cannot terminate without having established a statutory ground for possession. Under the new regime, how often can rent be increased? Hopefully you appreciate the maximum would be once per year, although in practice, if a tenant is going to be challenging the rent using Section 14 of the Housing Act, it's probably going to be slightly less frequent than that. What is the rule on rental bidding? Hopefully nobody thinks that it's going to be encouraged in any area, and hopefully you have all appreciated that rental bidding is going to be banned from the 1st of May. Question 6, which group can landlords no longer refuse to rent to solely on that basis? And the answer there will be benefit recipients. The ban on discrimination on the basis of children at the premises or receipt of benefits will come in on the 1st of May. What rights do tenants now have regarding pets? Well, they will have the right to request a pet subject to landlord's consent, which cannot be unreasonably withheld. And why might students face increased uncertainty with assured tenancies of student accommodation? And that's because tenants will be able to leave on a 2 months notice. They cannot be tied in to a fixed term. So in summary, from the 1st of May, there are going to be some major reforms to the assured tenancy regime. And from that date, all assured tenancies will become assured periodic tenancies with a maximum period of 1 month. ASTs, fixed terms, Section 21 no-fault evictions are all being abolished. Any existing assured tenancies are going to automatically convert to an APT on the 1st of May, although they will be subject to the transitional provisions I've outlined in this talk. Be aware of the deadline for those transitional APTs. Certain notices are going to have to be served by the landlord by 31st of May 2026. Under the new regime, rent increases can only be via the Section 13 process. There can be no contractual rent reviews, and rent reviews are going to be limited to a maximum of once per year, although in practice that's probably going to be hard to achieve. In terms of terminating an assured tenancy from 1st of May 2026, a tenant will be able to terminate on 2 months' notice. The landlords will only be able to terminate by establishing a statutory possession ground. Student lettings, if they are an assured tenancy, are in scope and will be subject to the changes. But note the expanded exclusion that will apply from 1st of May 2026, and also note how the new possession ground will operate and the concessions that will be afforded to those student lettings that are assured tenancies converting to APTs on 1st of May. And just be aware of the new duties that are going to apply. And of course, if you have any questions, advice on this topic, please reach out to your usual contact at Denton's, who will be able to assist. Many thanks for your time.